Good morning, my lord.
Good morning, Shobhan.
Yes, lordship. Good morning.
Audio is clear?
Yes, my lord.
Okay, thank you.
Lordship Tarapit. Madam, with madam.
Yeah, yes, Surya. Any mentioning?
Lordship, Lordship, I am praying leave, my lord,
Ah.
to file memo of appeal, my lord, without certified copy, order dated last Friday, and
Okay.
certified copy applied last Friday, my lord, order uploaded Monday, my lord. Two matters, my lord.
All right.
My learned junior is there in the court, my lord.
All right. Leave granted.
Lordship, may I leave to mention, Lordship, on for inclusion in the list, Lordship, review application, Lordship.
Yes.
My lordship,
Yes, sir.
without certified copy of the order, want to file appeal petition. So
What
pray
is
for my lord.
the date of the order?
Date of the order 19th May 2025, and I applied for certified copy on 22nd May, but not yet received certified copy.
All right, leave granted.
Lordship, may be permitted to mention a matter. This is an appeal against the contempt proceeding, Lordship, and notice has been served for
inclusion in the list, Your Lordship.
Yes.
Obliged.
Hotel side Delhi list. Item number 1.
My lord, I am appearing for the
My lord, I am
petitioner,
for
my
the
lord.
respondent, alleged contender, my
The
lord.
order has been complied with, my lord. Yesterday, the gold have been released by the
Right.
department.
We have heard so and so, so and so.
My lord, one indulgence, my lord.
Hmm.
My lord, in your lordship order on 12 June 2025, my lord.
No, 13th June,
30th June, my lord. 20th June, my lord.
20th June.
20th June, if your lordship kindly come to internal page number 3. My lord has in this law, in this order, my lord has stated that adjudication proceeding, show cause notice. Now, since my lord, you have released the goods, my lord, if your lordship kindly modify this order, my lord.
Which order you want to modify, Mr. Banja?
My lord, 28th May 2025.
Which paragraph?
My lord, page number 3. From last, my lord, from the bottom, third paragraph, my lord. Therefore, the authorities are restrained from adjudicating the show cause notice until further orders, my lord.
We have heard the learned advocates for the parties. In terms of the directions issued, by order dated 19th February 2025, it is submitted by the learned advocate for the applicant that the seized gold bars have been returned in terms of the provisional release order passed, subject to fulfillment of the conditions contained therein. Therefore, nothing further survives for adjudication in the contempt application. It is submitted by the learned senior standing counsel appearing for the respondent that in the order dated 20th May 2025, the authorities were restrained from adjudicating the show cause notice until further orders. In the light of the fact that the direction issued has been complied with, the order the order dated 20th May 2025 is modified to the extent by directing the authorities to proceed with the adjudication of the show cause notice. Needless to state that the applicant shall cooperate in the expeditious disposal of the adjudication of the show cause notice.
My lord,
Grateful, my lord.
my lord, may kindly grant me 2 weeks' time to file my reply to the show cause notice, my lord.
All right. The applicant is directed to file the reply to the show cause notice within a period of 2 weeks from the date of receipt of the server copy of this order, after which the adjudication proceedings shall commence and be concluded at the earliest.
Grateful.
Grateful, my lord.
Extremely grateful.
Grateful.
Item number 2.
My lord, I am appearing in this matter, my lord. There is a delay of 72 days, my lord.
Ah.
Mr. Khaitan is on the other side, my lord.
11 और 12 आपका 12 तक है
Sir, the other matter, we'll take it up someday. I sprained my back severely.
Lordship.
My lord.
That's why I told the court to inform Pratyush Jhunjhunwala as well as Mr. Kundalia. Today, delay can be condoned. What is the main purpose?
My lord, regarding my lord, this reopening was, according to the tribunal, reopening was made on the basis of borrowed satisfaction. But my lord, it is not the case, my lord. It is on the basis of my lord, independent satisfaction. This first question. My lord, second question is regarding my lord that regarding validity of reopening. This is also similar, my lord. And my lord, third question, my lord, question number D is regarding my lord the judgment of my lord Priya Blue Industries, my lord. That was not considered subject to my lord regarding my lord that which says my lord the holding the investigation report was not the sufficient for the assessing officer to reopen the assessment in while the said decision of the Honorable Supreme Court has ruled that where the assessing officer has reason to believe that the income chargeable tax has escaped assessment, the assessee has was beneficiary of the assessment the accommodation entry that on the basis of the formation of such belief.
Today we will condone the delay and take up the appeal for admission next week.
My lord, next week. Yeah.
We have heard so. There is a delay of 72 days in filing the appeal. As sufficient cause has been shown by the department for not preferring the appeal within the period of limitation, the delay in filing the appeal is condoned. Application allowed. Yes, sir.
My lord.
Item number 5.
My lord, 5. My lord,
The 2, 3, 4.
2, 3, 4. My lord, all 72 days. Similar
11, 12, 12, 13 and 13, 14.
different assessment year only. My lord.
Different assessment.
Yes.
So,
Lord,
item 5.
My lord, item number 5. I'm appealing. My lord, this delay of 134 days. My lord. Mr. Khaitan is appealing.
Here also, Lord, there are several questions.
Ah.
So that those can be taken up, Lord, in the next, on the 1st of July, Lord, the relay can be condoned.
Okay.
We'll prepare the chart, Lord. The chart is required because
Very good. Thank you. There is a delay of 134 days in filing the appeal by the department. As the delay has been explained and sufficient cause has been shown for not preferring the appeal within the period of limitation, the delay in filing the appeal is condoned. Application in GA 1 of 2025 is allowed. Same order in item number 6 also.
6. Yes. Yes.
Item number 7.
My lord, I'm appearing. There's a delay of 39 days. My lord. In this case. 39 days. My lord.
I appear for the respondent, my lord.
No, delay may be condoned. My lord will kindly take it on next week. Mr. Mitra is also appearing in this matter. My lord, Tilak Mitra is leading it.
My lord, this is covered by my lord's own order, my lord, in the case of Asta of income, my lord. I have shared the copy of the order.
Seven.
OD7 को OD7 order OD7 लेकर आ जाओ।
उन तीन अटैचमेंट दिए
नहीं एक ही दिए
ब्रोचो को पल
नहीं दिए
नहीं तो विजय को बाइक स्टार
हाँ
हाँ
All right, today we will conduct the delay.
Hello.
Then,
My lord.
but the Asta of income, what is the order?
My lord, I have shared the order, my lord. My lord, the department had preferred an appeal, my lord, against the ITAT order, my lord, that was dismissed by my lords. My lord, I had the privilege to appear in that matter before my lords. My lord, will have a look at page 113 of the ITAT order, my lord.
113.
My lord, page 113 of the ITAT order, my lord.
Yes.
My lord, paragraph 6 onwards.
Lordships can operate the.
Lord, before that, if your lordship will kindly see the assessment order and state. My lordship.
Then at page 114, my lord. My lord, we had submitted that it is covered by the judgment of Asta of income, my lord. And then the tribunal, my lord, at page 116, my lord, they've dealt with the judgment.
100. Yes.
My lord, at page 116, my lord. And in fact, my lord, a thorough exercise has been done, even to compare the cases, and a tabular chart also has been made, which my lords will find at page 118 of the ITAT order.
All right, today we'll condone the delay because we have to discuss all the judgments.
My lord. 39 days, my lord.
Delay condone, sir. Same order you can pass 39 days.
My lord. Get
Item number 8.
My lord, I'm appearing.
Hmm.
And Roy Chaudhary is online, my lord. My lord, the service hasn't been effected.
971 days.
Yes, my lord. But my lord, the issue is covered.
Covered.
Checkmate services case, my lord.
Pardon? Which case?
My checkmate services case, my lord. But my lord, there is also one issue. Just I am in doubt, my lord, about the tax effect. I should be candid, my lord. What have transpired to me, my lord?
82,000 only.
My lord?
82,382.
Yes, my lord. The issue is, my lord, the assessee failed to deposit the employee's contribution of PF and ESI within the due date, my lord. And the Honorable Supreme Court in the case of checkmate services has held that if the assessee fails to deposit, that should not be allowed. That will be treated as income of the assessee, my lord.
And what did the tribunal do?
Tribunal relied upon the judgment of Vijay Sri, my lord, of this Honorable Court, my lord. That is of 2014. Vijay Sri, that judgment is of 2014, but checkmate is of 2022.
Please check whether Justice Chatterjee is online.
Yes.
Yes.
Yeah. In the screen, it is not visible. Okay. But what was the reason for this 971 days delay? That is too much, sir.
My lord.
How to excess 900 and something? We have heard Mr. So-and-so, Mr. Samrajit Rai Chaudhary, Senior Standing Counsel, and Mr. Amit Sharma, and Standing Counsel for the Appellant Department. Though the respondent has been served, none appears for the respondent. The first hurdle that the department has to cross is with regard to the delay in filing the appeal. The impugned order was passed by the tribunal on 2nd of March 2022, and the certified copy of the same was received by the department on 18/5/2022. And the appeal ought to have been filed not later than
59/2022.
September 2022, but however it was being filed on 13/5/2022, and there is a delay of 971 days. The delay being inordinate and not properly explained, this court is not convinced to exercise any discretion in favor of the appellant department. That apart, we also find that the tax effect in this case is only rupees 82,382. Thus, for the above reasons, the application in GA number 1 of 2025 is dismissed. Consequently, the appeal stands rejected, and the substantial questions of law suggested by the revenue are left open. Yes, sir.
Item number 9.
Let I answer the appellant.
Your Lordship, in this matter, I generally don't oppose delay, Your Lordship, except that in this matter, there's been a delay of 285 days. Now, my lord, the facts are such that, my lord, the assessee, because of the delay, the assessee could not take the benefit of the VSV scheme, Your Lordship. Now, if I may just briefly explain, my lord, what had happened
But
in the matter.
suppose we condone the delay, can he exercise?
He can't, my lord, because what has happened, my lord, is that the time frame has expired. Even the extended time frame given by the CBDT, even that has expired, Your Lordship. And even on the portal, it is not available. However, my lord, there's a decision of my lords, a reported decision. I've shared that by email, Your Lordship, in CHC link 20. As item number 9, there's a reported decision. In fact, there are two decisions, Your Lordship. In one decision, my lords were in fact pleased to dismiss the department's appeal because of the prejudice caused as VSV scheme was no longer available. But I'll not go that far, my lord. I'll only rely on the second decision, wherein my lord says Aditya Saraf case. Third term. In this decision, your lordship has in fact granted the assessee the opportunity to avail the VSV scheme. And my lord, with the directions, my lord, in the last paragraph that, in fact, at page 2, your lordship, from the last two lines, that considering the peculiar facts and circumstances of the case, we are of the view that the assessee should not be non-suited for the default committed by the revenue in not preferring the appeal within the period of limitation. Identical issue arose for consideration before the Honorable High Court of Delhi in the case of IA Housing Solutions Private Limited versus PCIT in such and such. And the Honorable Division Bench by the said order allowed the writ petition and directed the revenue to accept the declaration application of forms 1 and 2 filed by the assessee as valid declarations. Application within the time frame and accept the balance disputed amount as stipulated by them under the provisions of the scheme. Thus, in light of the above, the appeal stands disposed of with a direction to the respondents to file the requisite application under the scheme within a period of 10 days from the date of receipt of the server copy of this application, and such application shall be deemed to have been presented well before the last date on which the benefit of the scheme had come to an end, and the application shall be processed and the requisite forms be issued so as to enable the respondent assessee to pay the disputed tax in terms of the conditions contained under the scheme. Such order shall be passed by the revenue within a period of 6 weeks from the date on which forms 1 and 2 are filed by the assessee. My lord, so this is a reported decision, my lord, wherein again it was a case of an income tax statutory appeal. And my lord, in my case, if
who appeared for the assessee in this case?
It was Mr. Asim Chaudhary, your lordship.
Can you verify from him whether any special petition was filed against this direction?
I can inquire from him, your lordship. Actually, I might be a little difficult because from what I understand, Mr. Chaudhary is now residing in US, your lordship. He's working as an advocate there. He shifted. But I can check the website of the Honorable Supreme Court because, my lord, the details are available. If we give the High Court the details of the matter before this Honorable Court, I can examine the website of the Honorable Supreme Court.
You also make an effort. And who appeared for the department in this case? You please scroll down.
Mr. Somen Bhattacharya had appeared, my lord, and he's also appearing in this matter. He's not here today, it seems.
Lordship, I'm led by Mr. Somen Bhattacharya.
He's appearing in this matter as well, your lordship.
But he is not present now in court.
No, Sovik, you yourself scroll the order down. I'm not able to scroll it. Down. No. You show the cost item.
This was under the old scheme, my lord. This was under the previous scheme.
Little higher. One more paragraph. One more. Stop. Soman Bhattacharya appeared now. Okay. So Ashim has shifted practice, is it?
Yes, your lordship. I can ask Ms. Shukla. She is still in Calcutta. I can inquire from her and also from the website of the Honorable Supreme
Court. There is a delay of 285 days in filing the appeal. The respondent assessee has raised objection for the prayer for condonation and seeks time to file affidavit in opposition. Let such affidavit be filed within 2 weeks from date. Reply, if any, within a week thereafter. List of case after 3 weeks. Sir, show the cost title. This the learned advocate appearing for the respondent assessee placed reliance on the decision in the case of PCIT 5 Calcutta versus Aditya Sharaf HUF 2023 4 TMI 391 Calcutta High Court, and submitted that under similar circumstances this court had directed the assessee to file the application under the Vivad Se Vishwas scheme. The learned advocate appearing for the appellant department as well as the learned advocate appearing with the respondent assessee shall ascertain as to whether any appeal has been filed by the department before the Honorable Supreme Court against the judgment in Aditya Sharaf HUF case. List the matter on so and so date. Give a date after 3 weeks. In the meantime, you get your affidavit in opposition also filed.
I will, man. I'm grateful, Your Lordship. I can, if I can even file. Should I also file an application, my lords? With an application where I'll be praying for this relief, or my lord?
Liberty is granted to the respondent assessee to file appropriate application.
I'm grateful, Your Lordship.
Item number 10.
I'm grateful, Your Lordship.
Yes.
This matter, there is a delay of 140 days.
Your Lordship, Mr. A.K. Upadhyay, advocate, is appearing in this matter, Your Lordship. He is currently indisposed. Kindly keeps the matter. Tomorrow, Your Lordship would just pass over the matter.
He wants to oppose the delay. We'll condone the delay today and hear the appeal for admission. Yes.
Very well, Your Lordship.
We have heard so and so. So there's a delay of 140 days in filing the appeal. As the delay has been properly explained and sufficient cause has been shown for not preferring the appeal within the period of limitation, the delay is condoned. Application in GA 1 of 2025 is allowed. List the appeal for admission. You give a date.
Item number 11 to 16. Item number 17.
Yes.
Item number 18.
My lord, this is my appeal, my lord. There has been a delay of 64 days, my lord.
18.
And
16 of 2025.
custom 16, yes.
16. And who will appear?
My lords, I appear for the respondent assessee, my lords.
No, Rahul won't oppose this delay. Delay is only 64 days.
Seven.
But one thing, Manasi, if the basic customs duty has been determined as 0,
my lord,
how a surcharge can be levied? For the purpose of calculation of surcharge, you will have to, because it has to be levied and collected based on the duty which is payable. If the duty is 0, then where is the question of payment of surcharge?
my lord, why, my lord? To our respectful submission is, my lord, the duty, the basic duty is payable by cash or through adjustment, my lord. If it is paid by cash, here they have paid it through scripts, my lord. So they have adjusted into through scripts as per the notification available to them. My lord, if the duty, the scripts would have not been available to them, they would have paid this duty through cash, by cash, my lord. Then this additional duty of surcharge would have also been applied. That is one, my lord. My humble submission to another aspect is also, in case of refund, my lord, if the basic duty has to be refunded to the assessee, if they have paid in excess, my lord, then the refund would be even if it is through paid through scripts, or if they have paid an additional duty, then we also have to refund them the additional duty, the SWS. So kindly, my lord, keeps it another day. I would rely on certain judgments.
You make a compilation, both of you, because tribunal is extensively.
Yes, my lord. And I have gone through the judgments, so I have found, and I hopefully I would be able to satisfy, my lord. But these two are our contentions, my lord, because here why they are saying
But apart from that, the tribunal in paragraph 12 says that in the assessee's own case, the coordinate bench of the tribunal has held in their favor.
So far I can remember, my lord, there is a Madras High Court judgment in my favor.
And one more, Bombay High Court.
Bombay High Court is in my favor, my lords. That is in my very own case, against which the SLP preferred by the revenue has been dismissed. So Bombay High Court was in my very own case, and the judgment which Mansidi is referring to, that is by Madras High Court in Gemini, against which the SLP is pending, my lords. Supreme Court has issued, has granted leave, and SLP is pending.
And what did the Madras High Court hold? Have you got a soft copy of that order?
My lords, I have a hard copy. My lords, right now I'm just carrying the hard copies, my lords.
But kindly keeps it another day, my lord, any day, my lord.
My lords, if my lord so pleases, can it be kept on the 22nd or 23rd of July, my lords?
Yes. 22nd or 23rd. Yes, any date. We have heard so and so. There's a delay of 64 days in filing the appeal with the department, as the delay has been properly explained and sufficient cause has been shown for not preferring the appeal within the period of limitation. The delay in filing the appeal is condoned. GA 1 of 2025 is allowed. Let the appeal be listed for admission on so and so date.
Deeply obliged, my lord.
July 23rd. Item number 20. Much
My lord.
18 and 19, same order. Same number of days?
Yes,
yes, my lord.
64. That is 62 and this is 64, I think.
Both the cases 64.
64. Okay.
Both the cases, my lord.
Same order. 18 and 19, same order.
Deeply obliged, my lord.
Much obliged. Item 20.
But item number 20, this matter was heard by your lordship. The Tilak Mitra was arguing the matter, my lord. Lordship will kindly take it up some other time.
I appear for the respondent, my lord.
It's
My lord,
not
I heard this
available today, my lord. This matter is Rajesh Kumar Jalan, my lord. 20 and 21, my lord.
All right.
Kindly take it up, my lord.
We have heard so also. At the request of the learned counsel for the appellant, list sometime next week.
Yes, my lord. Yes.
Under the same caption. 20 and
21.
Same, my lord.
Same, my lord.
Item number 22.
I am for the respondent, lordship, in this matter. So Mr. Tilak Mitra was appearing, I believe.
Lordship, I'm praying for a short pass over. Lordship, Mr. Shomin
Can take it up
Bhattacharya.
next week, lordship, as per my lord's convenience.
All right. Next week, we have heard from us also. Request of the counsel for the appellant next week.
Item number 23.
My lord, I appear for the respondent in this matter.
My lord, in this matter, I'm led by Mr. Mithro. He's not come.
Not available today. 263.
No, my lord, this is a reopening case, my lord.
My lord, there are two appeals, my lord. 147 and 263, both are involved.
Okay. That is item 23 and 24.
24. My lord, the tribunal has held in this matter that the matter was reopened on the basis of change of opinion, which is incorrect, my lord. And this judgment, this case issue is covered by the my lord's judgment of PL Goenka's case, my lord.
My lord, it is not in my favor, my lord. My lord, the objections were not disposed of. My lord, there are 3 to 4 cases, my lord, where the objections, if it has not been disposed of, my lord has been pleased to dismiss appeal on that ground only. My lord, this is one issue in which it is covered, and another issue is there that is also, my lord, covered in my favor by my lord's own judgment. My lord, they have invoked the larger period of limitation without any allegation that there is a failure to disclose any material from the assessee side.
My lord, I have judgment on this issue. A latest judgment of Bombay High Court.
My lord, I have my lord's own judgment in that issue against which SLP has been dismissed.
My lord, if kindly comes to page 34, my lord will find the reasons for which the case was reopened.
But the reasons they say that the assessee was connected with two companies. One is Samrat Udyog and the other one is Hitendra Commercial Private Limited. And some inquiry was being conducted.
Yes, my lord.
They say dummy directors, but the tribunal...
Two of the companies were struck off, my lord. Phantom Dealers and Hitendra Commercial, these two companies were struck off.
My lord, if I may indicate, my lord, this was a scrutiny assessment proceedings. My lord, first they had issued notice in respect of 3 companies. My lord, after that they issued notice in respect of 9 more companies. And my lord, then another notice was issued in which 1 more company was added. So my lord, total there were 13 companies in respect of which in which notice was issued. My lord, then the officer sought to make addition only on respect of 4 companies. So he had the information.
Okay.
He had the information of all, my lord. It was a scrutiny proceedings. The entire notices were issued. And then, my lord, on the basis of 13 companies, he proceeded only in respect of 4 companies. My lord, that is the case. And my lord, may then kindly have a look. That was the case, my lord. And in fact, my lord will see in the next matter, my lord, the 263 matter, they have sought to, they have initiated 263 because the officer has initiated proceedings only on the 4 companies. And in 263, they are initiating proceedings on the other 9 proceedings, in which 147 was not initiated by the officer. My lord, that is the case, my lord. So that is why the tribunal says it is a change of opinion, because the officer had formed a belief after sending the notices that these 9 companies, out of 13, only 4 are required to be assessed. My lord, that is the brief point before my lords.
Okay.
My lord,
And in fact, my lord, may kindly have a look at page 37, my lord. Page 37, para 7, my lord. He is not disposed. The officer has not even disposed of the objections, which is, my lord, contrary to the GK and drive shaft case.
Well, that ground was not taken. On what ground what point the tribunal has allowed the appeal? If the ground is not taken before the tribunal, can the assessor take the hair? Here, my lord, the tribunal has watched the proceedings only on the point that it was a change of opinion.
Now, where is the 148 notice?
148 notice is not annexed, my lord.
Because one of the grounds raised is the notice itself is bad in law. Because the columns have not been struck off. And that ground they had canvassed.
Here the ground is that the CIT appeal has erred in confirming reopening of the assessment by issuance of notice under section.
No. Before CIT appeals, page 16, ground para 3, ground number 3. It's a defective notice. That is one point they have raised.
My lord, I will ascertain from the assessing officer.
My lord, may kindly have a look at page 47 of the ITAT order, my lord, for a moment, my lord. Page 47.14, my lord. My lord, the ITAT, my lord, may kindly have a look. My lord, ITAT has held that the notice was issued after expiry of 4 years. And my lord, as per the proviso to section 147, my lord, there is no allegation that there has been a failure to disclose fully and truly all material facts necessary. My lord, the tribunal has proceeded on this basis also.
Okay.
My lord, on this issue, I will cite a judgment, my lord. If my lord grants me time, I will satisfy my lord on this issue, my lord.
So we'll condone the delay today.
Delay has been condoned.
Delay is condoned, my lord. This is for admission.
Where are your substantial questions?
Page 5, my lord.
But what they say, the 263 proceedings is time barred.
Yes, my lord, that is time barred, my lord.
See, if it is
My lord, that is another issue, another case, my lord, 263.
maybe it's a common order. 143.3, the original assessment was 143.3. And the order is dated 28 September 2021. No, it's a reassessment order, is it? Under 147.
Yes, first one is 147 order. It's a reassessment order, my lord.
All right. So if you...
Tribunal is in doubt whether the case was, the 263 was invoked for the original assessment order. Or
no, if you only if you succeed in that appeal against reopening, you can argue the second appeal.
Yes, but that way I was on that point, my lord. That's why, my lord, I was submitting that.
Revenue is not successful in the 147 matter.
Then that also goes, my lord. Yes.
The original order was passed on 16th December 2015. My lord, that
So,
was
my lord,
143.3. My lord, it was a scrutiny.
My lord, the first, let these first cases be decided, reopening case be decided.
All right. If you want to get some judgments.
My lord,
may have it next week.
All right. We have heard the so-and-so learned advocates for the parties. The learned advocates on either side seek time to place some list under the same caption on so-and-so date. This will be from 23 and 24.
24, my lord. And my lord, 25 and 26.
My lord, I'm grateful.
25 and 26.
My lord,
I am appearing.
my lord, this matter be taken up next week, my lord, because in this matter also I am led by Mr. Mithro, and he said that he will do this matters.
And who will appear for the SSC?
My lord, I am appearing in this matter.
Mr. Agarwal appeared. He's online.
You are not able to see him.
He's
My
online,
lord,
your lordship.
He's online, my lord. I can see.
appearing. I think some video problem may be there.
In my screen, Mr. Agarwal is not visible.
Mr. Agarwal is visible from here.
Some problem in my screen. Now it's visible. All right. We have heard so and so. At the request of the learned advocate for the appellant, list next week.
I'm grateful, ma'am.
Number 27.
My lord, I am appearing for the respondent SSC, my lord. My preliminary objection, this appeal is not maintainable because of that. In the SSC's case, already NCLT approved the resolution plan. And in this regard, I already referred one of the order. You lordship kindly remember on Monday, I handed over the hard copy of the order as it would be placed in the record. My lord, that is for the assessment year 2014-15, my lord. And it is recorded.
Very recently, we passed a detailed order.
Yes, that is APOT 72 of 2025. Against the writ petition, I preferred one mandamus appeal, my lord.
72 of 2005.
72 and 71 of 2025. It is for the two assessment year. And
what is the date?
Date of the order, my lord, I have to check, my lord.
But can we get a copy of the order from the system? We'll ask the ACO.
Yes, my lord, at the same time, I have given this
it is not
small order.
It has not been put up along with the file. You had handed.
Your lordship kindly remember on Monday, that is why I mentioned.
It is not here in the file.
That is the order. This is another order date. That is the order of. I am telling my lord, what is the ITAT 147 of 2024. It is a short order. It is 260 appeal.
Prey Infrastructure Finance Limited.
Yes, my lord. Yes, my lord. This is the same SSC's case.
It's there in this.
It is for the assessment year 2014-15, and present case is for the assessment year 2017-18.
Same SSC, is it?
Same SSC. Same.
And what is that appeal?
And
ITAT?
Appeal is the. This is the SSC's appeal. This is the same SSC's appeal. ITAT 147 of 2024. Date of the order is 24th of May 2024. And small rectification done after that. That is on 28th June of 2024.
For the assessment 2013-14.
It is for the assessment year. Yes, sorry, my lord. I am extremely sorry. It is for the assessment 13-14, not 14-15. 13-14.
One second. Please show the first page. Top, cost title. Seri equipment. Same APOT 71 of 2025 and 72.
No, it is SREI equipment, but it is the case of SREI infrastructure. That is the same group, under the same group, and NCLT order.
Mr. Basu, which paragraph will be relevant in this APOT order?
Actually, my lord, I am relying upon the order of the ITAT today. That is very short order, and it covered the entire case also, my lord. So that is why, that is, if your lordship kindly ask them to provide the ITAT 147 2024, it will be very easier for me.
ITAT 147.
147 on 2024.
This must be.
There is a two order. On the first day, there is some There's an error in the line, that is why it is rectified. The last paragraph, my lord, your lordship was pleased to record.
24th.
This is 24th of May 2024.
All right. Please take down. This appeal has been filed by the Revenue under Section 260 capital A of the Income Tax Act 1961, challenging the order passed by the Income Tax
ITA 1157 whole 2025. A bench.
A bench Calcutta within bracket tribunal in ITA number 1157/KOL/2023 dated 29/4/2024 for the assessment year 2017-18. Similar order was passed in the assessee's own case for the assessment year 13-14. Is it? 2013-14. And the Revenue filed an appeal before this court in IT 147 of 2024, which was dismissed by judgment and order dated 24th May 2024. The operative portion of the order reads as follows. Sir, please scroll down, show the relevant paragraph slowly. Go down.
At page 5.
Page 5.
Page 5. Only one mistake is there, my lord, is a third line. That respondent company going into liquidation. Instead of liquidation, it should be CIRP, Corporate Insolvency Resolution Process. And this is rectified by the order dated 28th of June 2024. Subsequently.
In the said appeal, the submission was made by the learned advocate for the assessee that the respondent company has gone through a corporate insolvency resolution process, CIRP, which was approved by the National Company Law Tribunal by order dated 11th August 2023. Since the resolution plan has been approved by the NCLT, the Revenue cannot pursue the appeal, and therefore the said appeal was dismissed. In the instant case, the said order would squarely apply to the case on hand, as it concerns the very same assessee for the subsequent assessment year, namely 2017-18. For the above reasons, the appeal stands dismissed, and the substantial questions of law suggested by the Revenue are left open.
Lordship, I'm led by Mr. Shomen Bhattacharya.
Yes.
Grateful, madam.
Item number 28.
I'm for the appeal, my lord. My lord, this issue is that the addition was made under section 68 in respect of share application, money and premium money. The shares of face value of ₹10 were issued at a premium of 1990 rupees to the corporate applicants, and these shares were also issued to the promoters group, but those were issued at par. My lord, kindly come to page 59 once, my lord. My lord, in the CIT appeal had called for remand report from the assessing officer, examined again all the details and upheld the addition. My lord, kindly come to page 59, paragraph 5.2. My lord, from fifth line, my lord. Considering the facts of the case in the light of the above decisions of the coordinate benches and jurisdictional high court, we are in agreement with the conclusion of the CIT appeal. The CIT appeal has upheld the addition.
That's a mistake.
And accordingly set aside
it should be, we are not in agreement.
Not in agreement.
But then the tribunal has referred to This Naina distributors, what happened to that case?
Naina distributors, my lord.
It is quoted that a relevant paragraph at page 58, para 5.1.
Yes, my lord. 5.1. Yes, my lord. Naina distributors.
But where is the finding of the tribunal in this case?
Nothing, my lord. That's good. The tribunal has relied upon these two judgments, my lord, and here the findings basically that discussed, my lord, para 5, page 53, my lord.
But then the tribunal says it issued summons to the directors under 131. It was of the summons to the director of the assessee to produce certain documents. Of course, that was complied with. They produced proof of identity, voter card, passport, driving license, PAN card, list of entities, subscribers, directors of shareholders, ITR, audited accounts, bank statement, source of funds. Then they also filed the share allotment chart, details of share applicants and share applications, copies of audited financial statement, ledger account, bank statement, as well as all evidences in respect of subscribers, comprising of PAN, copies of audit account, along with bank statement, auditors, so and so, so and so, so and so, so and so, and assessment orders under 143.3 of 5 subscribers, source of source certificate of 5 subscribers. But the AO has not conducted any inquiry. That's the finding of the tribunal.
But that
Your
is not
Lordship, if I may
my
submit.
lord, kindly see that first assessing officer's order and CIT appeals order also, my lord. I'm first citing, my lord, CIT appeals order.
Your friend wants to say something. Yes.
Your Lordship, I'm led by Mr. Obro Mojumdar. Your Lordship, the issue in this case is that, first of all, the tax effect is merely of 64,24,110, and this does not fall within the exception clause 8 of para 3.1 of circular 5 of 2024. Secondly, Your Lordship, the entire...
But they say it falls within the exception clause in para 3.1H.
Yes, Your Lordship, but this is not a case of organized tax evasion or accommodation entry. The issue in this case is that the SSE issued shares to 10 subscribers. 5 of them were companies and 5 of them were directors and promoters. Now, the thing is that, Your Lordship, the entire reassessment proceedings have been conducted in a very mechanical manner because initially, there was when the SSE went before the CIT appeals, the CIT appeals called for a remand report from the AO. That remand report, the AO has not disputed the identity, creditworthiness, or the genuineness of the transaction. The only comment that has been made by the AO is that if the subscriber companies are ready to accept the additions, then otherwise everything is fine. Now the thing is that all these subscribers have been assessed under 143.3, every one of them, and there has been no adverse comments on their assessments. So everything, the identity, credit, the only issue, the addition made by the AO is...
No, you come to the, Mr. Amit Sharma wants to refer to the AO's order. In page 17, the assessing officer says in response to that, the assessee company filed certain preliminary details. But he does not say about following details. Yes.
One of the things is that, Your Lordship, as would be evident from page number 24, paragraph 3, The SSC, the director of the SSC company, Mr. Mahesh Kumar Soni, sought for time because as he was out of station, but the assessing officer did not provide him the time, and he made the addition solely on the basis that the directors of the subscribers company did not make appearance. Now, this is also to be noted that, Your Lordship, no individual notices were issued to the directors of the subscriber companies. Notice was issued to me, and then they were called for the personal appearance of the directors of the subscriber companies, but no individual notices were issued to the directors of the subscriber companies. Your Lordship, it would be
But
evident.
one thing, Mr. Sharma,
My
when
lord,
they produce all the documents, the AO doesn't discuss about it.
my lord, the AO has not elaborately discussed, but the CIT appeal has discussed everything, my lord.
Their submission is remand report was called for, and the remand report he did not dispute it.
No, my lord, my lord. Kindly that relevant portions are at page 47 starts. CIT appeals order, my lord, page 47. Here the credit worthiness, my lord, the CIT appeal has relied on the credit worthiness of the investors, my lord. Identity may have been proved, but my lord, the other limbs are also required to be proved. Credit worthiness as well as genuineness of the transaction. Here the CIT appeal has held that credit worthiness as well as genuineness of the transaction have not been established.
The assessing officer did not dispute the same in the remand report because all the transactions were done through banking
My lord,
channels.
I'm reading out the relevant paragraphs, my lord. Paragraph page 47, para 6.1.2. It is seen that the assessee issued dismissed shares having face value of ₹10 each. The assessee charged premium of 1990 per share. The premium charges were 19,900% of the face value. The premium of this much is extremely high, and even very well known, reputed, high earning publicly listed companies do not enjoy such high premium. Therefore, remand report was called for. And my lord, page 48, these are details of the investors. How much shares were, what price these were issued?
The only reasoning given by the CIT appeals is that the premium was given at a higher rate to the companies. But Your Lordship, as would be evident from page number 49, the CIT appeals have itself stated wrong facts while adjudicating in the decision portion itself at page 49 that notices and summons were issued to the subscribers for necessary verification, but these notices remain non-compliant. However, no notice was issued. So the entire proceedings have been carried out in a very mechanical manner with a predetermined mindset, Your Lordship.
In the appeal before the tribunal, have you raised this ground?
Yes, Your Lordship. In paragraph 3, page number 53 of the stay application. If Your Lordship would kindly have paragraph 3 at line 30.
State that the AO has not issued any summons under 131 or notices of 133(6) to the individual subscriber. So this is factually incorrect. Page 49 finding, factually incorrect.
Yes, Your Lordship.
That is one thing. But where is the the discussion in the remand report? He has not extracted that.
Remand report is not available in the stay application, but when the SSC submitted before the CIT appeals, the CIT appeals has re-extracted the submissions of the SSC, and the same would be evident from page number 29. Last paragraph.
No. He has not extracted the full remand report.
No, that has not been annexed with the stay application.
All right. What was your explanation for offering shares at 1990 and a premium of 1990 and with a face value of 10 for 5 companies when you issued the same shares to your directors on par. There should have been some explanation given. Page 29, you come. It would be apparent from the balance sheet of the 5 shareholders that they had sufficient capital to make contribution. Suresh Kumar Danwar, Sony. All right. In respect of 5 corporate shareholders, namely, while letter dated, the assessee filed all details called for. The AO did not dispute the identity of the 5 shareholders. Further, the AO did not adversely comment on the documents and evidences. You do one thing, you file a compilation, let the assessee file a compilation containing the explanation which he offered. Initial notice, they would have sent a letter along with the enclosures. Then copy of the remand report, full text of the remand report.
Yes, Your Lordship.
Yes, it is you. The assessee should file. Huh?
Sure.
We have heard so and so, so and so. The respondent assessee is granted leave to file a compilation containing all the communications which are submitted by the assessee pursuant to notices issued by the assessing officer along with enclosures, as well as the copy of the remand report submitted by the assessing officer dated 25/6/2018. The assessee shall also bring on record the submission made by them to justify the share premium of ₹1990 per share, having a face value of ₹10 in favor of 5 corporate shareholders, in respect of which were sold to 5 companies. Okay, 2 weeks.
I'm grateful, Your Lordship.
Number 29. This is my matter. This is penny stock case. The case was reopened. My lord, like in recent cases, my lord, the tribunal says that reopening is bad.
So it's not a penny stock matter, Your Lordship. If I may humbly submit.
Let me finish, my lord, then my lord can have it. My lord, the information was received from the DIT investigation regarding this matter. And the case of the shares in which the assessee had transacted is in the list of those companies, my lord. And the conclusion of tribunal is at page 41, my lord. Para 6. My lord, in this case.
But the tribunal says that the assessee has not earned any long-term capital gain.
No, my lord, that is the thing. No, my tribunal has held that assessee has not claimed LTCG. But here, tribunal has held that the assessee has claimed LTCG and short-term capital gain type, both. So both are to be disallowed, my lord. Because these are not the genuine gains. And my lord, original return was.
Please come to page 41. Let us be clear on facts. Page 41.
My lord.
Third line, page 5 of the paper book, which indicates assessee has earned capital gain from sale of shares of AMS, but has not earned any long-term capital gain.
Yeah, yes, my lord, long-term capital gain.
Had earned short-term capital gain and has paid income tax at 15%. Further, we notice short-term capital gain has arisen by reducing the purchase cost of shares at so-and-so against so-and-so. It thus indicates that there's some information about sale of EMS industries, but assessee had not claimed any exemption under 1038 of the Act of rupees so-and-so. And he did not, tribunal says the AO did not examine his original return.
No, my lord, the return was processed under section 143(1).
Maybe.
That was not a scrutiny proceeding, my lord.
No, it is a 143(3).
No, this, my lord, earlier, originally. Original return was.
I have the original assessment order number 143(3). That is dated 28th of November 2014. What has happened was that I had paid the tax. I had showed that the shares with regard to this VMS Industries, that is there in the return. I have the paper book which was filed before the Commissioner Appeals. I apologize, Lordship, we don't have the soft copy of that. But and that was sold within 12 months.
Sir, Mr. Sharma, the application itself, based on which reopening was done, is that the assessee has claimed exemption under 1038. On facts, it has been held that no such exemption had been claimed. What is the answer for that?
My lord, I will take instruction from the assessing officer regarding whether because it is not clear from these papers, my lord, whether the assessee had claimed exemption or not.
No, it is clear. Please come to page 12, para 2.
Para 2, my lord.
Para 2. Specific information was received from the officer principal so-and-so.
This is the information, my lord.
Claimed 90 lakhs so-and-so.
Yes, my lord.
1038. But the case itself is they have not claimed anything under 1038. That is the on facts. Please be clear. Once again, I'm saying.
No, my lord, that was. I want to ascertain from the assessing officer.
No, tribunal is recorded, Mr. Sharma. On facts, it is recorded. It has not earned any long-term capital gain, and he has not claimed any exemption under 1038 in respect of this 90 lakhs 95,000. Page 41, it is clear. Therefore, the tribunal has allowed us appeal. And in your grounds, what have you said? Whether the tribunal committed a mistake? You would not have. Yes, sir. Please come to page 7, para 14, second question.
My lord.
Whether the assessee is entitled to tax exemption under 1038 when the records and material indicate the alleged income shown as LTCG is result of a. But the contention itself is no LTCG was claimed. CIT's order is an ex parte order.
Yes, my lord. CIT order is ex parte.
Page 33, paragraph 4. That this 12.
That extracted portion
Lordship.
About 10 or 12 lines from the top.
Lordship.
Correct.
Lordship.
So and so. However, the AO has reopened the assessment of 147 specific information received principal DIT investigation that the appellant has claimed an amount of 1995,000 as exempt under 1038, which arose out of so and so. It is not understood as to where from the AO had got the information of the appellant having a gain of so and so, in which according to the appellant is STCG 5746,787, which has already been offered for tax in the original assessment itself. Records of reveal that there has been no long-term capital gains by the appellant in the shares of EMS as alleged by the AO, and this itself goes to prove that the reopening, invoking the proviso to 142, has got no legs to stand itself to be annulled. Sanction of the notice on the offences, bad in law, various observations 143.3 relate to various theses relating modus operandi, etc., etc.
They have dismissed the appeal only because of the fact I couldn't respond to the notices. My Lordship sees that paragraph 6, page 36, 6.2. So this fact that I have offered for tax and there was no long-term capital gain, it is clearly on record because I have in the case of the original assessment proceedings.
So,
part of the paper book filed before the Commission of Appeals.
If the reopening itself was on wrong facts.
Mere information. They are saying a mere information from the investigation wing. The reopening itself was bad. That the ITT has dealt in detail, Your Lordship. The only issue is regard to these shares pertaining to VMS Industries and this information. Simple information from the investigation wing. No, ठीक है.
On facts, there is nothing, sir. Unless you would have raised a ground saying that the tribunal been because the CITA notes the statement of fact which is not rebutted. All right, please come. This appeal has been filed by the Revenue under Section 260 Capital A of the Income Tax Act 1961 against the order dated June 24, 2024, passed by the Income Tax Appellate Tribunal C Bench, Calcutta, in ITA number 345/KOL/2024 for the assessment year 2012-13. The Revenue has raised the following substantial questions of law for consideration. Page number 7 of the stay petition, question number 1, question 2, 3, 4 not required, 5, 6 not required. We have heard so and so. The tribunal, by the impugned order, allowed the appeal filed by the SSC and set aside the order passed by the appellate authority dated 22/12/2023, by which the assessment order dated 27/12/2017 passed under section 143(3) was affirmed. The order passed by the first appellate authority was an ex parte order on by observing that the assessee did not respond to the notices of hearing issued by the appellate authority. The matter relates to reopening of the assessment under section 147 of the Act. As could be seen from the assessment order dated 27/12/2017, the reopening of the assessment was on the basis that specific information has been received from the Office of the Principal Director of Income Tax (Investigation, Mumbai), dated 28/3/2019, that the assessee has claimed an amount of rupees 90,95,000 as exempt under section 10(38) of the Act, having arisen on a scrip called VMS Industries Limited. The learned tribunal has elaborately considered the facts and has pointed out that this is the information based on which the reopening was done was factually incorrect. The undisputed facts are that the return of income submitted by the assessee was processed under the provisions of section 143 within bracket 1. Full stop. The appellant had a long-term capital gain as per accounts amounting to rupees 41,98,896 after adjustment of long-term capital loss of rupees 4,62,646, which was claimed as exempt under section 10 within bracket 38 of the Act. However, the assessing officer reopened the assessment under 147 on specific information from the investigation wing at Mumbai that the assessee had claimed an amount of rupees 90,95,000 as exempt under section 10 within bracket 38 of the Act, which arose in the shares of a scrip called VMS Industries. There is nothing on record to indicate as to where from the assessing officer secured such information that the assessee claimed had a gain of rupees 90,95,000, which according to the assessee is a short-term capital gain of rupees 57,46,787, which was offered to tax in the original assessment itself. Furthermore, it is clear from the records that there has been no long-term capital gains by the appellant in the shares of VMS Industries as alleged by the assessing officer, and therefore the learned tribunal was fully justified in holding that the reopening of assessment was bad in law. When the assessee has not claimed any exemption under section 10 within bracket 38, the question of reopening would not arise. Therefore, the learned tribunal, after examining the facts, has rightly allowed the appeal filed by the assessee and set aside the orders passed by the assessing officer as well as the first appellate authority. Thus, we find no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, the appeal fails and dismissed. Whether appellate side they are ready? No.
My lord, the next item is covered issue, my lord.
Covered issue.
Number 30. Article 30, I am for that.
Covered by assessee's own case?
No, my lord. Supreme Court, Abhisar Buildwell. Item,
It
this
is
was
not.
a search
It
case.
is not. It is not covered. First, let me place my case and then you will say that. This assessee, there was a search and seizure operation in Siliguri of the premises of Bharat Exports. Now, these Bharat Exports had purchased coke from iron ore fines from the assessee, and which was valued at 8 crores 3 lakhs. The assessee in its accounts have shown that it had purchased iron ore from one Navabharat Exports Private Limited of rupees 13 crores 83 lakhs. Now, these 13 crore 83 lakhs, the person on whose place the search and seizure took place, he had shown in his sales, in his purchase, and here that he had purchased goods worth 13 crores 83 lakhs. So, if the assessee has shown that he has sold iron ore for 8 crores 3 lakhs, and the purchaser had shown that he had purchased, and from this assessee, the iron ore worth 13 crores 83 lakhs, Milord, therefore, a sum of 4 crores 20 lakhs was, Milord, was the suspicion that this amount, Milord, the assessee has not disclosed and, Milord, shown that this as a loss. Milord, subsequently, the assessee could not, Milord, produce any documents to substantiate its claim, and it was found that the goods were sent to, Milord, China. Whereas,
Mr. Dutt, actually what they are, the additional ground was allowed to be raised before the tribunal, stating that the assessment proceedings was not based on any incriminating material which was recovered during search. And therefore, they referred to this whatever judgment, Buildwell or
builders.
Builder.
Milord,
Para
that
nine.
is not the case, because in that case, there is a certain seizure operation had disclosed, Milord, this bank account at Siliguri belonging to Axis Bank, which is the incriminating document.
All right, we'll take up the matter next week. Next week. We have heard so and so next week.
Oblige.
Milord, next matter, Milord, kindly also take up next week.
The next matter, Milord, I am appearing for the respondent.
Milord, I am for the petitioner, Milord, kindly take it up next week, Milord.
Milord, we'll come back next week, Milord. One of the rare matters where, Milord, CIT appeals and ITAT both found in favor of the assessee. Milord,
next week. We have heard whether advocates for appellate side are here.
May I be permitted to mention, pray for leave to file this appeal, appellate side. Appeal without certified copy. Order was passed on 21st May 2025, and I applied for certified copy on 23rd, my lord. My lord,
leave granted.
Oblige your lordship. And 3 admission matter, my lord. 3 admission.
Inclusion, yes.
Inclusion, my lord.
To mention a matter for upgradation, my lord, is item number 94 in the monthly list of June. My lord, the petitioners are the doctors who are getting a very meager amount of salary, wherein the similarly placed doctors having the same qualification and the same work experience are getting a much higher salary.
You please give the latest.
Lordships, may I mention serial 25 of the monthly list of appellate side. This matter is regarding the jurisdiction of Bureau of Investigation to adjudicate in case of WBGST. It was posted for hearing since last year, Lordship. Now, in the meantime, recovery proceeding had been initiated. The demand was around 4 crores. So we had filed an appeal before the appellate authority, Lordships. Now, appellate authority has dismissed my appeal on the merits, on the ground of delay, stating that because there is no stay from the division bench, so you should have filed the appeal at the appropriate time against the adjudication order. Now, against that delay, I am filing a new writ petition before the learned single bench, Lordships. My only submission, because your Lordships, it's a continuous every year. This matter before your Lordship is of 17-18, then 18-19, 19-20, 20 up to 22. The same issue is pending, Lordship. If it can be upgraded any week, any day next week, subject to your Lordship convenience. Serial 25.
Next week.
Lordship generally takes Tuesdays, appellate side, group 4 matters. Or any day, subject to your Lordship's convenience.
We'll have it after 12th July.
Lordships, fine. Lordship. I'll again mention that. I'll again bring to your Lordship.
Yes, please.
Grateful.
My lord, may I pray for a leave to file this appeal without certified copy? Order was passed on 19th May. It is not my matter, my lord. My learned friend Sanjoy Shaw has requested me to pray for leave, my lord. My lord, on 19th May 2025, the order was passed. Applied certified copy applied on my lord. My lord, 12. My lord, can it be, my lord, pray for leave to file this appeal?
Yes, leave granted.
Much obliged.
Yes, sir.
Appellate side, daily listed matter, item number 1.
But I appear for the state respondents.
Against the order of the tribunal, is it?
Respondent. That's it, Captain. Raju, see that data?
They have come up against the order of the learned tribunal, taxation tribunal.
It's Raju, see the sure.
Mr. Chatterjee is here.
Mr. Dugar was supposed to be there, Your Lordship.
He joined. We saw his name. We have admitted him.
Anil Dugar was supposed to be there.
তুমি করো না
আমি কি করব আমাকে তো ব্রিফিং নেই
আমি দিয়েছি ডক্টর
হ্যাঁ
My lord, I am suffering. My lord, I am appearing, my lord, virtually.
Yes.
Yes.
My lord, I am suffering from viral fever and my lord, acute throat infection. My lord, item number 1 and 3.
All right. We'll have it next week.
Yes, yes, my lord.
We have heard so and so, so and so at the request of the learned counsel for the writ petitioner. This next week, item 1 and
1
3.
and 3. I'm grateful.
Item number 2.
1 and 3.
But item number 2 also I appear for the state respondents. This has also come up. They have come up against the order passed by the Learned Taxation Tribunal. Mr. Sumit Ghosh and Shoridip Mojumdar.
Where is the order of the tribunal?
The order of the tribunal is at page 50. তিন নম্বরে কি আমাদের আছে?
না বলছো তো দাদা আগে 2 মিনিট চলে গেলে থাকতে বললাম আমি চলে গেল না বলছো তো
বলে দিচ্ছি ওটা আমরা শুধু 1 নম্বর ছিলাম 3 নম্বর আমরা
So what was the tribunal says some serious allegations have been made against the members of the authority discharging a very important statutory duty. What allegations did he make?
He said, my lord, that they had produced the document before the Fast Track Divisional Authority, but that was not taken into consideration by the Fast Track Divisional Authority. Though the Fast Track Divisional Authority says in its order, which is appearing at page 36,
that no such document was produced.
No such document was produced. Page 37, my lord, if your lordship kindly see in the middle portion, for the instant case, the purchaser has claimed ITC on such purchase which was not supported by the tax.
But who appears for somebody? Sumit Ghosh. All right, not today.
Not. This will come next week, my lord.
All right.
I'm grateful.
Yes.
But I am there in this matter and the earlier matter. I was not there in item number 3. Mr. Duga mentioned item number 3. I do not know. This is not concerning state GST or tax matter.
Okay. 1 and 2, you are there.
1 and 2.
Matters arising out of Group 6 for admission, item number 4 with 5.
My lord, so far item number 5 is concerned, I am appearing on behalf of the writ petitioner respondent.
My lord, before my lord takes up item number 4, my lord, Mr. Bikash Ranjan Niyogi is appearing for the respondent, my lord. He is out of station for treatment. I am praying that this matter be taken up after 24th, my lord, 24th of June.
But I am for the appellant, my lord, 4 and 5, my lord.
So for the 5 is concerned, my lord, I am appearing on behalf of the writ petitioner respondent, my lord.
My lord, the issues are also pending before Supreme Court, subject to correction, my lord.
So far the issue is, my lord, pending before the Supreme Court is, my lord, arising out of the contempt application. There, my lord, the principles.
Why we had complied with the order, the court said not a non-compliance.
All right. Once on health grounds on after 24th. You give a date after 24th. Record their appearances and then adjourn the matter.
I'm grateful.
Deeply obliged.
4 and 5, my lordships.
4 and 5.
Item number 6. 6, my lord. I appear on behalf of the respondents, my lord. Respondent. Single respondent.
Yes, sir.
I am appearing on behalf of the appellant, my lord. Well, this is an appeal against an order of the Honorable Single Bench setting aside the order of dismissal in case of a member of CISF, my lord. The ground of setting aside was that the punishment was disproportionate.
What was the charge?
Well, he my lord, was caught beating up another member of CIF. When that person got very seriously injured, my lord.
And how, according to the learned judge, this was not, it's very serious.
Possibly, your lordship, can you see from paragraph 39, my lord, possibly because it was a scuffle. My lord. A word was used, my lord, where it was termed as a scuffle. And my lord, this, your lordship, kindly see paragraph 39. In present case, one employee has been punished for incident of scuffle, where other was not held accountable. The second part is absolutely incorrect, my lord. The other person was also charged, my lord.
Okay.
So, my lord,
no, there is a direction for reinstatement, is it?
Yes, my lord. No, direction for the order has been set aside, and since he has retired, my lord, all pensionary benefits have been directed to be paid.
All right, then we have to hear the appeal, sir.
Yes, my lord. Yes, my lord. There is a delay, my lord, 144 days application. There is an application also.
That's subject to what your friend says. We can condone the delay.
My lord.
We will admit the appeal and take it up.
Yes, my lord.
Whether all the documents are there in the stay petition?
Yes, my lord.
Then paper book is not required.
Not required.
This state petition we can hear sometime in July.
Grateful.
No, my lord, may I humbly submit one thing, my lord? My lord, though this an application under section 5 of the Limitation Act has been filed, yet, my lord, the order was passed on 26 June 2024 by the learned single judge. My lord, the department applied after about 6 months on 6/11/2024. 6/11/2024. Only the reason they have shown, they could shown that there were interdepartmental communications. In my humble submission, that cannot absolve the.
Then you do one thing, sir. You file your affidavit in opposition.
Grateful. Well, usually in Union of India matters, unless the superior authority grants us leave to file an appeal, we have to get this approved by them. This delay was on account of sending their files to the superior authority, and then appeal was filed. Decision was for appeal was taken.
But then your friend says that there is a delay of almost 5 months in filing the copy application.
Another thing, my lord. Another thing, my lord.
Cannot be condoned.
Then let them file, my lord, the affidavit in opposition. We will, if necessary, will give the necessary document.
You have heard so and so, so and so. The learned advocate appearing for the respondent respondent petitioner opposes the prayer for condemnation of delay in filing the appeal. Leave is granted to the respondent to file affidavit in opposition within 2 weeks from date. Reply if any within a week. List the matter after 3 weeks.
My lord, I do not know if any contempt petition has been filed, my lord. if that has been done, that may kindly be.
What? See, 5
No, my
months.
lord. After serving the contempt notice, they have filed this appeal, my lord. For no contempt has been filed. It is my
No contempt has been filed, my lord. So, my lord, lordship can stay, my lord.
No. Let us see. Let them,
Great.
because objecting to the delay.
Yes, ma'am. Great.
Item number 7.
Grateful, ma'am.
Item number 7, Your Lordship, I pay for the appellant.
There is already an interim order.
The interim order is till 25th of June, Your Lordship.
Very good. We'll extend that. Who will appear for the bank?
Mr. HON'BLE is appearing for the bank.
HON'BLE is not here.
I have also informed him by a notice that Your Lordship will be taking up appellate side matters today from 12:30 or immediately after completion of the original side matters.
All right. We have heard the learned advocate for the appellant. We have heard the learned advocates for the parties. Since the appeal has to be heard, the interim order already granted and which was extended till 25th June 2025 is extended till 25th July 2025. List the matter on 23rd July.
Item number 8.
Grateful.
Yes.
In this matter, my lord, I beg to appear on behalf of the appellant state. There is a delay of 123 days. And my lord, the earlier 2 times time was taken for filing affidavit in opposition against the delay. But till date, no affidavit in opposition has been filed.
My lord, I appear on behalf of the respondents, my lord. My lord, we were directed to file an affidavit of opposition, my lord. However, my lord, it appears, my lord, can 1 has been misplaced by my office, my lord. Therefore, I have sought leave of my learned friend to provide me with a copy of the can so that the affidavit in opposition can be affirmed and filed, my lord. Therefore, my lord, kindly, my lord, directs my learned friend to serve a copy, my lord, and grants me 1 week of time, my lord. I shall be back before your lordship with my affidavit of opposition, my lord.
Probably you take his copy, take a photocopy and return it.
Grateful, my lord. Grateful.
It is submitted by the learned advocate appearing for the appellant, respondent, that though time was granted for filing affidavit in opposition to the application for condemnation of delay in filing the appeal, the copy of the application has been misplaced by the learned advocate for the respondent and requests 1 more copy to be provided. Let the learned advocate for the appellant is directed to provide a copy of the Can 1 of 2025 to the learned advocate for the respondent during the course of the day. The time for filing the affidavit in opposition is extended by 1 week from today. List the matter next Wednesday.
Item number 9.
Grateful.
Yes.
Lordship, I am for the appellant in this matter. Your Lordship, as per your directions, I had served my learned senior the copy of the annexures of the writ petition, but I wanted to rely on those before your Lordship. If leave may be granted to file a supplementary affidavit to bring it on record or any other day as your Lordship will be physically sitting, the matter may be
Your
taken
Lordship,
up.
kindly see the order impugned, my lord.
No, she wants to bring something on record. Let us bring leave granted to file a supplementary affidavit to bring on record the documents, the annexures filed in the writ petition.
Your Lordship.
List next week.
Obliged, Your Lordship.
Item number 10.
In this matter, I am led by Mr. Kishore Dotto. He is on his legs. I am praying for an adjournment. It's our appeal.
Okay.
Well, regarding appeal against the order of contempt. My lord, it is maintainable or not. My lord, last occasion, my lord, order passed by your lordship. The maintainability point hard passed.
Yes.
Next order.
Next Wednesday. Next Wednesday.
Grateful.
At the request of learned advocate for the appellant.
Item number 11.
11, may I please, Your Lordship, I am for the petition. This is my petition of service. Mr. Bhonjo is appearing on behalf of the Union of India. What happened, I approached people, I preferred this appeal, present appeal, for interim order. The learned single judge was admitted the writ petition and directed it to file the affidavit in connection with the writ application, but refused to pass any interim order. My case is that, if the interim order is not been passed, this matter can may be infructuous and respondent at the time of succeeding of my writ application. They may be submitted that now we have no vacancies. Presently, the vacancies are there.
Your prayer was to re-examine the medical fitness.
Yes, that has been allowed. That with regard to that effect, the affidavit has been called for. Prima facie, the learned trial judge was satisfied with my case. I have made out my case. Two different documents on their instance, they are saying that I am within the zone of consideration. But having regard to that, without considering that documents, they have rejected my candidature. That is my case. All about it. That has been satisfied by learned.
No. In the meantime, to reserve one post and all.
One post should be reserved. Otherwise, ultimately, if I succeed my writ application, then my prayer may not be considered, because at that point of time they will say that
this will unsettle the entire selection process, sir.
No, I am not praying any stay of the selection process. There are some vacancies. I have some documents.
Once again.
I have the document, I have annexed with my writ application, my stay application.
We will not grant any interim order. Where is the prayer for interim order? There is no observation that it has been rejected. You please read the impugned order.
Yes. This court is
considering the issue involved in this petition, so and so, is you that there is no scope for any. You succeed. Yes. You succeed. This court appeal is directed against an order passed, interim order passed by the learned single bench dated 6/5/2025, holding that there is no scope for passing any interim order as sought for by the appellant to reserve one post. The learned judge has called for affidavits to be filed, and dates have also been fixed for such purpose. Unless and until the petitioner succeeds in the petition, the question of the petitioner being directed for a re-examination of his medical fitness would not arise. Therefore, the question of granting an interim order pending writ petition is not feasible of consideration. Hence, the learned single bench was fully justified in refusing to grant any interim relief. Appeal dismissed.
Grateful, man.
Item number 12.
Affidavit service may kept.
Affidavit of service kept on record. Item 12.
For the appellant. I'm for the appellant. For the respondent. Lordship, today we are praying for a small Passover. The on-record advocate is just on the way. If a small Passover could be granted for the same, I'm for the appellant, Your Lordship.
My lord, just to delay, my lord, they are doing this. My lordship kindly comes to the learned single bench order, my lord.
I put an objection to that, Your Lordship.
My lord, it is a question of appointment, my lord.
All right, she wants a Passover, but today we have fixed that MGNREGA matter at 12:45.
Okay, Lordship.
So we'll say,
Your Lordship, I'm so sorry, Your Lordship. I'm the advocate on record and I have just appeared, Your Lordship. I beg your pardon for a little late, Your Lordship.
No problem. But 12:45, we have fixed up another matter, sir. That is item.
Lordship, this matter can be taken up after 2 p.m. Your Lordship. Will be present there in the court, Your Lordship, physically present there.
Item 20, 27, 23. All right. We'll say Passover. Let us see. Next.
Grateful, Your Lordship.
Grateful, Your Lordship.
Item number 13.
My lord, I'm appearing on behalf of the respondent in this matter, my lord.
Lord, I appear for the appellant.
This is, my lord, against the order passed by the learned single judge disposing of the application of the petitioner was a director of the institute and allowing my lord, him to get the allowance where it was a consistent stand that there was serious fraud and mismanagement. It was referred to vigilance, to inquiry. He was allowed to retire. Everything was paid to him. And then this allowance is kept pending. Now, what the learned judge has done, he has, on the basis of our prayer, directed that allowance to be paid and then to initiate a disciplinary proceeding. Now, my lord, this is absolutely in contradiction with the basic principle that once an incumbent has retired, he is no longer in service. If he is paid the amount and if in the disciplinary proceeding it is found he is guilty, how this is to be recovered? Therefore, my lord, the other point is that it has been filed during the vacation. I have been requested to appear. We need to file a supplementary affidavit and additional grounds. Whether the other aspects of this matter, which was being initiated and investigated by the vigilance and the inquiry team, whether that can be reopened, because this is a question of pecuniary loss to the government caused on the conduct of the director. And he, since was the director, it is our instruction that he did not allow the other things to be investigated against him during his career. So therefore, kindly grant us liberty to make an application to file a supplementary affidavit and additional grounds, and this order has to be stayed.
My lord, may I just, humbly, my lord, kindly takes up the order which is appearing at page 81, my lord. My lord, at page 83, till date, no disciplinary action has been taken, my lord, against the writ petition, respondent writ petitioner, my lord. Even in the documents which were not placed before the learned single judge, however, has been annexed with the stay application, which is appearing at page 70, it will be evident that no action till date has been taken.
But was the retired employee intimated that?
Not at all. Not at all. No demand certificate was issued prior to his disciplinary, prior to his retirement, which was also annexed and showed to the learned single judge, which is appearing at page 82, second paragraph, my lord. That no demand certificates were issued by the institute. Thereafter, he retired.
Well, kindly find the last but one paragraph. The learned judge is allowing to initiate a disciplinary proceeding. At the same time, he is recording that petitioner still has an unblemished career record.
No, my lord, kindly read. May I just read the pertinent portion of the order, my lord? Page 82, my lord. Ms. Choily said, learned advocate for contra referring to Annexure P2 at page 15 to the writ petition submits a no demand certificate has already been issued on November 9, 2023. The writ petitioner had retired on 31st of December 2023, my lord. In favor of the petitioner prior to his return, after considering the rival contention of the parties and upon perusal of the materials on record, it appears through this court that save and except earned leave encashment benefits, all other benefits have already been released in favor of the petitioner upon his superannuation on December 31st, 2023. Today in May 2025, my lord, the employer has not yet initiated any disciplinary proceeding as submitted by the learned counsel for the respondent recorded above. In view of the above, this court is of the considered view that at least up till now, the employer was not at all serious to investigate upon the alleged charge against the petitioner. Petitioner still has unblemished career record. This employer is not at all diligent. Employed is not at all diligent, assuming though not admitting that there is allegation of charges according to them. The superannuation benefit of an employee is the property of the employer, and his right accrues to receive the same immediately on the next date of retirement unless any fetter is created in the established procedure of law. In the facts of this case, there is no such fetter created. Accordingly, the respondent number 4 and or respondent number 5 and or any other appropriate authority of the respondent number 3 is directed to forthwith disburse and pay the earned leave benefit earned by the petitioner arising out of his employment positively within 4 weeks from the date of the communication of this order. However, this order shall not preclude the employer to proceed against the petitioner if they are entitled to so in law, and if ultimately in such proceeding the result comes in favor of the employer shall be at liberty to proceed realization of on
No, sorry for interruption. One small clarification, additional Solicitor General.
Yes, my lord.
The employee no demand certificate was issued on 9th of November 2023.
Yes, madam.
Sanction order was for pension and gratuity, GPF, etc. was given on 22nd December 2023. Retirement order was given on 31st December 2023 and 29th December, and 31st December he retired.
Yes, madam.
Till his retirement, you have not commenced any disciplinary proceedings. Rule 9 of the pension rules, what are the pension rules for this department, we don't know. Generally, the pension rule is if an employee is permitted to retire and disciplinary proceedings were initiated prior to retirement, and that would result in recovery proceedings of some financial loss or misappropriation, then it can be continued. He can be permitted to retire and continue. Here, investigation, I don't know when it started. And
started yet, my lord.
And he has been permitted to retire, no demand certificate issued. Now to withhold the leave encashment, how it is possible? It's without jurisdictions. And in fact, the liberty granted by the single bench to proceed itself is without jurisdiction. I mean, beyond jurisdiction.
May I make one submission? If your lordships kindly find at page 19 that there was the audit report and all these things, that question which has fallen from my lord the Chief Justice, whether during the pendency, the service career of the incumbent, whether initiation of a proceeding was made and thereafter it can be done. Now, I respectfully agree that after the retirement, the contact between the employer and the employee ends.
Yes, exactly.
But there are a category of cases if the inquiry is initiated for deciding such issues prior to this, not particularly against this incumbent, and if there is a financial loss detected on the conduct and behavior of the incumbent, whether this burden which is now cast upon the government for such an act can be reopened. That is the separate aspect. This aspect we are now agitating before your lordships is whether the learned judge had the jurisdiction to allow us to initiate a disciplinary proceeding after payment of the allowance.
No, that is, in fact, that liberty itself is wrong. Because
if we succeed in the disciplinary proceeding, then how shall we recover that amount?
No, his leave encashment has been withheld by the director on the ground that it will be released subject to the report of the inquiry committee. So till date, no inquiry.
No committee has been formed, my lord. My lord kindly takes up page 70, my lord. My lord, page 70 of the stay application.
Yes, we have got page 70. I have already.
Yes, my lord. Yes, my lord.
Page 70, the annexure. If you see.
Annexure F, my lord. Yes.
72. The name of Dr. A. Vishwas mentioned in so and so of C.R. Patana, resulting which the leave encashment is withheld. The leave salary may be released subject to the reporter. So
subject to the
inquiry committee is not constituted, there may be a lot of people. So therefore the amount is only 34 lakhs, I think. How much is it?
35 lakhs.
Poor fellow, sir. He has been allowed to retire and national.
This particular leave encashment benefit, which was not obtained during this service career at time of retirement, whether in page 83, if your losses kindly find once in the list towards the middle of the observation of the learned judge.
You could have sanctioned provisional pension. You could have sanctioned provisional pension, saying that because of the inquiry, which is audit report, inquiry committee is to be constituted and gone into. Therefore, we cannot sanction you pension. We will sanction you provisional pension. This is subject to the outcome of the inquiry committee report and further proceedings.
That aspect I am not agitating today. I am simply asking and praying before your lordships, the learned judge, while allowing us to initiate disciplinary proceeding, can he say that the payment of this allowance to be paid to him And in the event we succeed in the proceeding, disciplinary proceeding, then we shall recover. How shall we recover? There is no procedure laid down for such recovery. This aspect has stayed now.
The pension is being paid.
Pension is being paid, my lord.
Pension is being paid. You
So
can
that pension and below this
Can they
leave
withhold
encashment
my?
benefit.
Madam.
I'm sorry, I
You
apologize.
don't give this running up.
I
ASG is on his legs. You please wait for your turn.
Yes, ma'am. I apologize.
Leave encashment benefit below is completely different from pension. Pension has been categorized by the
leave encashment has been withheld, sir. Leave encashment accrues to a person because he has not availed leave at the time of retirement. He will be entitled for encashment. So the learned judge has given you liberty. You initiate inquiry committee. After the inquiry committee finds something wrong with him, probably the committee may summon him. Then if it is found out, you make a charge proceedings. That liberty is already being granted. In the meantime, to withhold, that will be unreasonable.
Then when not the petitioner, in the event he is being paid this leave encashment benefit,
the payment will be subject to the outcome.
He has to give an undertaking that in the event this disability proceeding it is found he is guilty, then he has to pay back.
All right. We'll safeguard your interest to that extent. Okay. This intra-court appeal has been filed by the central government and its authorities, challenging the order passed by the learned single bench in WPA 8996 of 2025, dated 2/5/2025. The said writ petition was filed by the respondent, praying for a direction upon the appellants to where is the prayer in the writ petition?
Page 7980, my lord.
Praying for a direction upon the appellants to pay the leave encashment dues of the writ petitioner amounting to 34,67,500 in accordance with the Central Civil Service within bracket leave bracket close rules 1972 together with interest. Direction was also sought for to consider the representation wherein the same relief has been prayed by the writ petitioner. The undisputed facts are that the writ petitioner joined the National Institute for Locomotor Disabilities, being the third appellant in the post of assistant professor on 2nd of August 1993. As he was to attain the age of superannuation on 31/12/2023, the pension papers were processed and a no demand certificate was issued by the Deputy Director within bracket administration, certifying that dated 9th November 2023, certifying that there are no dues payable by the writ petitioner to the third appellant organization. Subsequently, an order was passed on 22nd December 2023, sanctioning gratuity and pension, and the GPF ledger card and pension payment order were handed over to the writ petitioner. The order of retirement was issued by the third appellant dated 29th December 2023, and the writ petitioner retired attaining the age of superannuation on 31st December 2023. Thereafter, the writ petitioner had made several representations seeking leave encashment dues, which were not considered, which necessitated the appellant, the writ petitioner, to file the writ petition, which has been disposed of by the impugned order. The learned additional solicitor general submitted that the direction issued by the learned single bench is incorrect, since the learned single bench has directed payment of the leave encashment benefit and simultaneously granted liberty to the appellants to proceed with the
departmental
proceedings. and such direction could not have been issued. We have heard the learned advocate appearing for the respondent petitioner on the above submission. What is the learned single bench has rightly noted that till the date of retirement of the writ petitioner, that is on 31st December 2023, no disciplinary proceedings has been initiated against the writ petitioner. That apart, no due certificate was issued as early as on 9th November 2023, and pension has been sanctioned and gratuity has also been paid, and orders to the said effect have been passed on 22nd December 2023. It appears that as could be seen from the proceedings of the director of the third appellant dated 19/8/2024, the leave salary was withheld and ordered to be released subject to the report of the inquiry committee. It is the submission of the learned advocate for the respondent petitioner that till date the inquiry committee has not been constituted. Be that as it may, as on date, no disciplinary proceedings have been initiated against the respondent petitioner, and therefore the appellants are not justified in withholding the leave encashment benefit payable to the appellant. Therefore, the direction issued by the learned single bench is perfectly justified. That apart, the interest of the appellants have also been safeguarded by the learned single bench, wherein by observing that the order and direction issued in the writ petition shall not preclude the employer, namely the appellants, to proceed against the writ petitioner if they are entitled to do so in law, and if ultimately in such proceedings the result comes in favor of the employer, then the employer, shall be at liberty to proceed for realization of the earned leave benefit to be paid to the writ petitioner as directed in the said order in accordance with law. Therefore, if the appellant department is entitled to proceed as per law against the writ petitioner, they are at liberty to do so, and the observations made that apart, it was made clear that the order passed in the writ petition shall not create any right or equity in favor of the employer in any manner whatsoever for initiating any proceedings or recovery against the writ petitioner. Therefore, we find that the interest of the appellant has been sufficiently safeguarded by the learned single bench while issuing direction to disburse the earned leave benefit earned by the appellant writ petitioner during his service. Therefore, we find no grounds to interfere with the order passed by the learned single bench. Accordingly, the appeal fails and dismissed, and the appellants are directed to comply with the direction issued by the learned single bench within a period of 4 weeks from the date of receipt of the served copy of this judgment and order. Yes, sir. Thank you. We'll stop with this and take that
MGNREGA matter, item number 23 to 26.
Yes, sir. Where is that affidavit? Central.
I appear, Milord, for the state.
Yes, sir. You show the order book.
But if your Lordship may kindly have a look to the order of 10th of April.
Order to last order is.
That's it.
Yes, sir. In fact, Learned Advocate General, when the matter came up on 16th,
yes, Milord,
he passed an order noting that in paragraph of the order dated 10th April, directions have been issued to the appropriate authority of the central government, as also in para 11 and 12.
Yes,
the Standing Council appeals are submitted, affidavit has been sworn in, and it will be filed on the next year.
Yes.
And in respect of the
Milord,
state,
yes, I'm so sorry. I'm so sorry.
A direction was issued in para 14, for which the Common Council day before yesterday requested time because you are appearing in the matter and awaiting instruction. So we said today we will consider what is the stand of the central government, where the direction issued in para 10 of the order dated 10th April, 10, 11 and 12.
Yes, sir. Yes, sir.
Yes, sir.
But may I only make one submission, Milord?
Yes.
I think, Milord, this matter will take some time. Whenever it's convenient for the court, it may be tomorrow, day after tomorrow, Milord. Let us, Milord, do it, Milord, physically, Milord, subject to what my learned friend appearing for the petitioners submits, Milord.
We will do that. We like to know the stand of the central government.
Yes.
We have already filed the copy of the Honorable Second Judge's copy and the original may hand over. Possibly a scanned copy has been.
Yes, I got it. Now, sir, if you can have the 10th April order side by side.
Yes. 10th April order and the direction issued upon us, we have given in detail para-wise in the report. Kindly allow me to place the report in detail, because this is required. Because there are, my lords were under the impression that only in respect of 4 districts the inquiry was made, and as such something was found. Now I submitted on the last occasion, and that is also recorded. Apart from the 4 districts, there are other districts where inquiry was won, and if my lords come to the writ petition of 555, that is also listed before your lordships. Their inquiry report or detailed inquiry report of the Rural Development Department was filed. Apart from these 4 districts, there are other districts. Now, in the report which we have filed pursuant to lawsuit direction on 10th April 2025, it starts from actually the answer to the questions raised by your lordships from para 3 onwards. No, Milord, I'm sorry, Milord. Not 3. Actually, para 5 onwards. Para 4 onwards.
4 onwards.
Before reply, Milord, I'll still have to read it in detail, the para-wise, on line by line, because before replying to the specific queries put forth by this honorable court, by the solemn order dated such and such, having reference to the respondent number 1, begs to submit as follows: that under Mahatma Gandhi National Rural Employment Guarantee Act 2005, the fund released to the state is a continuous process, and central government is committed to making funds available to states for implementation of the scheme. Funds are released to the states, union territories periodically in 2 branches, with each tranche consisting 1 or more installments, keeping in view several factors such as sanction labor budget, demand for works, opening balance, pace of utilization of funds, spending liabilities, overall performance, and subject to submissions of relevant documents. It is also pertinent to mention here that a robust online platform called MGNREGA Soft is in place, to which updation of information at every level is done by the concerned state, union territory, and on basis of the information of MGNREGA Soft and funds are released as per the provisions envisaged under the Act. Central government releases 100% of the wage payment directly to the bank accounts, post office accounts of the beneficiaries through the National Electronic Fund Management System thereafter. Now, this is the explanation given as to how it is being disbursed. Now, para 6 onwards kindly come. In reference and or reply to the paragraph 10 Roman I of the solemn order dated such and such passed by the Honorable Court, the respondent begs to state that as per Rule 238 of the General Financial Rules to 2017, all interest or other earnings against grants in aid or advances other than reimbursement released to the grantor institution should be mandatorily remitted to the Consolidated Fund of India immediately after finalization of the accounts. Therefore, the question which fell from my lords on the last occasion was, what was the recovery of misappropriation of the amount where it has to be transmitted? Now, this is the answer in the Consolidated Fund. Now, then, such advances should not be allowed to be adjusted against future releases. In view of the above, the state government should deposit the recovered amount into the Consolidated Fund of India. Accordingly, the state government should remit the recovered amount through a demand draft drawn in favor of the Pay and Accounts Office, Ministry of Rural Development. The last question is answered.
One clarification. Sir, this inquiry, now we will not go into the other districts because in the next paragraph, I read the affidavit, full affidavit. Other paragraphs you have said, another set of team has visited, etc. Another 15 districts are going on. First, for the time being, we will restrict to 4 districts. If this amount, according to the central team or visiting team or whatever team was constituted by the court, etc., certain irregularities have been found. Admittedly, there were irregularities. Therefore, the payments made out to those people have been ordered to be recovered, remitted to a particular nodal officer's account. But their consistent case of the petitioner was, there might have been 10 bad apples, but still there are people who have genuinely worked. They are not being paid. That's the, sir, from the beginning of so many hearings, we are trying to make that issue clear. We are not saying anything about your inquiry into irregularities, illegalities, which you are bound to make. No person can benefit from by a fraud committed. But if there are 10 people who have genuinely done the work, why do you
we are not standing in the way, but what two aspects we are, two aspects.
You can't get it back, sir. If you
would it be Loss's pleasure to see once in the list paragraph 9? Paragraph 9 of the report. Page 10. Page 10. In reference and a reply to the paragraph 13 of the solemn order, the Honorable Court regarding release of pending wage and material payment under Mahatma Gandhi such and such, which arose prior to date of Ministry's letter dated 9th March 2022, the respondent begs to state that due to non-compliance of various directions related to transparency and accountability, the request of the state government for upward revision of labor budget for financial year 2021-22 was not agreed to be the empowered committee in the department. Therefore, payments towards wage, material and administrative components for the period prior to 9th March 2022 have not been made. In this regard, the latest action taken report dated 23rd October 2024 and updated action taken report dated such and such, taken report such and such, from the state level been examined and further observations have been conveyed to the state, read a letter dated such and such for necessary compliance and clarification as stated above. Photocopy of such and such. Therefore, my lord, the question of payment to those who have really worked, we respectfully agree with your lordship. Now, what is the case made out by the Khet Majur petition, the first petition before your lordship? Applications were made to the district magistrate in the concerned districts. Now, who is to assess whether these people whose lists are being enclosed, whether they have worked or not?
Not on that. With deepest respect to my learned senior friend, at the moment we are not agitating that issue at all, sir. With respect to previous payments, my lords, we have clarified this earlier occasion also. In the meantime, it has been cleared and pending wages have been cleared by the state of West Bengal, my lords. At the present moment, my lords, we're considering the specific issue of prospective implementation of the law. Whatever has happened, my lords. Today onwards, how the law can be prospectively implemented for that.
We'll come back to you. Solicitor General, one issue. There was a direction that pending payment of and material payment, wage payment, material payment, if any, prior to the order dated 9th March 2022, will be released by the central government. That was the understanding. Now two issues arise. So if there was another direction issued to the state government in that order dated 9th March in paragraph 10 subpara 2i's, which the state government is contesting. They have filed a supplementary affidavit, they are contesting. Our query is twofold. Whatever has happened has happened. Let us say that 80% is illegal. You draw a line and you have a cutoff date, because now this scheme has not been implemented for close to more than 2.5 years in the state.
More than 3 years, my lords. 3 years, 2 months.
So therefore, let us make a beginning as, let us say, by July or August 2025. Prospectively, you start. That is why we said, what are the checks and balances you could make? You put a nodal officer of the central government who will disburse the funds. He will scrutinize the application, because you cannot suspend the implementation of the central scheme.
May I make, in this regard, may I make a respectful submission?
Yes.
In view of the action taken by the central government on a proven fact of misappropriation on the release of the central government fund, an action has been taken under section 27 of the Act of 2005 Act.
Yes.
It is true that the scheme cannot be indefinitely stopped. That's true. But when an action has been taken under section 27, state government has been asked to satisfy by filing one after other action taken report, and unless we are satisfied whether the central government will release funds further. That is the question, Lordship will kindly decide. Kindly see the scope of section 27.
Their stand itself was 22 compliance report has been filed. 22 times they have filed compliance report. So we are not saying anything on that. For the present, we will say that all was not well at the earlier point of time. You please have a cutoff date. Prospectively, you implement the scheme from August 2025. That will be beneficial to, that will be honoring the statutory mandate.
I'm grateful, Your Lordship.
And you impose any condition. You will say that you will not release the fund to the state.
Millard, could I,
on the last occasion,
may I make one submission, Millard, for your Lordship's assistance? Millard, now, Millard, the central government, Millard, has come out with a portal, National Electronic Fund Management Portal, under which, Millard, the money would be directly transmitted to the accounts of the beneficiaries, Millard, electronically. Therefore, nodal officer and all, Millard, that would also, Millard, may not be required. My learned friend may take instructions on this also. But this is what, Millard, I wanted to say.
No, I think, sir, that will be a better option, sir.
That is the system that is in place, Your Lordship. If I may put this is a system that is in place since 2016, Your Lordship. Money, wage, so far as wage component is concerned, my lords, it is directly transferred from...
Central government stand is that there is a clear proof of misappropriation. Therefore, I will not release until things are clear. We for the present, we will accept their stand to be correct, because illustratively or factually it has been established, at least in 4 districts as of now, there has been irregularity.
My lords.
So our endeavor is to ensure that the scheme gets implemented prospectively.
My lords, I'm grateful, my lords.
Parallelly, they will proceed with regard to the past action.
I'm grateful.
People recover amounts, remit it to the fund, etc. Let them do. That will be proper, sir. That will be proper.
I'm grateful.
May I just, pursuant to Lordship's observation on the last occasion, may I just now repeat? Your Lordship had been pleased to observe on the last occasion, there should be a transparent procedure for looking into the investments made by the Government of India under the scheme, supervision of not to misappropriate again, which has occurred and admittedly done. Now kindly come to page 6 of our report. Page 6 at the top.
I cannot have any objection to this.
Top. States should ensure recovery for all such works where due process was not followed.
Yes, they will do. They will do.
And my lords had been pleased to hold on the last occasion on a finding of the nodal officer's report and also the admission of the state in their affidavit
saying
555 writ petition that there is misappropriation and total amount is this quantified. So what should procedure shall we follow for disbursement and maintaining the accounts?
Let them take all measures for
Wait. Shamim, wait, please. Sir, page 6, 1, 2, 3, 4, 5, 6, 7. All directions will be implemented by the state. But those directions are in respect of things works which have been alleged to have been allotted 3 years before.
My lord, some grateful. Yes.
And what about the future? Then your lordship had been pleased to observe on the last occasion.
Sir, please implement it prospectively. We will say that the scheme may be made operational from August 2025. At the same time, whatever is the observations, directions given by the central government in this report should be strictly implemented by the state, the investigating teams, the court monitored team, everybody will work. These are all things which occurred prior to 2022.
I'm grateful.
And then kindly also grant leave to the central government to have an overall supervision of the disbursement of the fund and payment.
Sir, you don't. That is what the Learned Advocate General also suggested. Please, we don't want to put our hands anywhere. Because the moment we put our hands, there may be an allegation that there is a likelihood of embezzlement, likelihood of misappropriation. You deal directly. The DM will give the names of the employees. Probably they'll upload the work. You have said blanket permission for land development should not be done. And DPC may be directed to accord sanction on a case-to-case basis. Yes, all these directions they will strictly implement, and the fund to be transferred to the beneficiary account, and where they can verify whether the beneficiary is available. It can be recorded. You evolve whatever procedure, but please implement this.
Yes, kindly grant that liberty.
Yes. Reference may be made to the order dated 10th April 2025, wherein there were 2 sets of directions issued, one to the appropriate authority of the central government and one to the state government. For the present, the direction given to the state government is not taken up for consideration, as the written instructions with regard to such directions is awaited from the appropriate authority of the state government. The relevant paragraphs of the order dated 10th April 2025 are quoted here and below. Paragraph 10 of the order dated 10th April 2025. Paragraph 11.
Labor budget.
Labor budget for the financial.
In response to the issues which were pointed out in the above paragraphs, the Undersecretary to Government of India under Ministry of Rural Development, Department of Rural Development, within bracket Mahatma Gandhi NREGA, has filed an affidavit. In the said affidavit, the directions which were issued in the aforementioned paragraphs have been dealt with in seriatim, and it will be beneficial to quote the relevant paragraphs of the said affidavit. Please quote paragraph 6, paragraph 7 of the affidavit, whole paragraph 7. It runs to 3 pages. Paragraph 8, 9, up to paragraph 9. I think Mr. Tiwari can give a soft copy of this.
Yes.
So that when they retype it, there should not be any.
Yes. I'll supply.
Yes. it is not in dispute that certain irregularities have been pointed out by the central team in the matter of disbursement of the wages under the centrally sponsored scheme. Action has been initiated, recoveries have been made and remitted into an account which is being remitted, and the recovered amount is lying in the state nodal account of MGNREGS West Bengal. In the affidavit filed with the authority, as quoted above, it is stated that the said amount has to be remitted to the Consolidated Fund of India, and accordingly the state government should remit the recovered amount through a demand draft drawn in favor of the Pay and Accounts Office, Ministry of Rural Development. At this juncture, the endeavor of the court is to ensure the implementation of the scheme in the state of West Bengal, which has been kept in abeyance for the past close to 3 years. It cannot, none can take a stand that a person who had obtained a benefit illegally should be allowed scot-free, and that he should enjoy the benefits which he had obtained by adopting illegal means. Such of those persons have to be dealt with firmly, and whatever disbursements have been made in those favor, in such persons' favor or in fictitious persons' favor, have to be recovered, and there can be no second opinion on the said issue. At this juncture, the court is concerned about the implementation of the scheme in the state of West Bengal prospectively. The scheme of the Act does not envisage a situation where the scheme will be put to cold storage for eternity. There are sufficient powers vested with the central government to inquire into irregularities or illegalities in the manner of disbursement of the wages or in the manner in which approvals have to be granted, etc. However, there can be a line drawn between past actions and future steps to be taken to implement the scheme. This, in the considered opinion of this court, would be in public interest and would subserve the object and purpose for which the Central Act was enacted. Therefore, while allowing the central government to proceed with the inquiries as recommended by the central team, not only in 4 districts, but also in other districts, as mentioned in the affidavit, paragraph 7 of the affidavit, para 7, as quoted above, this court directs that the scheme be implemented prospectively with effect from 1st of August 2025. While doing so, the appropriate authority of the central government is fully empowered to impose special conditions, restrictions, regulations, etc., which have not been imposed in other states in the country, so as to ensure that no illegality or irregularity occurs while the scheme is being implemented prospectively from August 2025 onwards. The Learned Advocate General submitted that the payments are to be made through a national portal, and there can be no intermediary in the matter. As observed by us, since irregularities have been found, committed have been identified, recoveries have been made, the matter is a serious issue which cannot be lost sight of. Therefore, while implementing the scheme in the state of West Bengal, prospectively from August 2025 onwards, the central government and the authorities of the central government who are in charge of implementation of the scheme are entitled to impose special conditions so that to ensure that whatever had occurred 3 years prior should not recur.
Yes.
Full stop. Necessary steps be taken in this regard, and special directives be issued and communicated to the state government, and thereafter the directives state government, which also shall contain the specific directions to the district magistrates. Apart from that, the issues which have been pointed out in paragraphs, in para 7, subpara 2.
Subpara 1 to 7, my lord.
No, wait. 1 is recovery, sir. Subpara 2, namely that blanket permission for land development work should be stopped and DPC should be accorded sanction on a case-to-case basis. The other subparagraphs,
kindly similar paragraph 5 also.
4 and 5.
Last paragraph, bottom.
No, this is recovery, sir. Prospectively, I'm saying. 7, you come to 7. State to ensure CIB at every work site. What is CIB?
Central investigation.
Central investigation, CIB. No, it's not central investigation.
So now blanket permission will not grant. Apart from that, the central government would be entitled to impose any other special conditions that would warrant and ensure that the scheme is effectively and properly implemented in the state without giving any room for any irregularity or illegality being committed. The state shall comply with the directives. State shall strictly comply with such directives that
Citizen Information Board.
And such directions which may be issued by the central government are non-negotiable, and they have to be accepted ipso facto by the state government and implemented. Only if this is done, the citizens of the state of West Bengal will be benefited, and there will be works can be performed, and they can be paid the wages which are in effect minimum wages, and the rural population which is to be benefited out of this would benefit and this payment would be a succor, SUCC, to the rural population in the state.
Well, CIB is Citizens Information Board, CIB.
All right. Any other condition also?
And recovered amounts will be transferred to the hospital.
And the other thing which your lordships have been pleased to observe on the last occasion, which you have disclosed, that the recovered amount shall be transferred to the consolidated fund of.
That we have recorded. Full stop. With regard to other aspects, the court will take up the matter, will consider on the next hearing.
Millard's unemployment allowance issue, Millard's, with respect.
You do, sir. Wait, sir. Wait.
I'm grateful, Will.
You give a date, probably immediately after Independence Day.
Millard's, kindly expense because unemployment.
Please, otherwise it will be released. See, Shamim, it is high time he gets polished better.
I'm sorry.
There are ways.
Well, we are grateful to Lordship. Whatever order.
Even your senior will not do this. You have to learn. Then why are you attached to a chamber? You have to learn.
Grateful.
We'll stop with this. Thank you.
But item number 20 and interim order is expiring, my lord.
28 interim order extended. When do you?
20 and 21, my lord.
20 and 21.
But there was a direction for filing of compliance report. May I place the report with my lord's record only?
No, next time we'll take it, Mr. Chatterjee. The interim order.
My lord, in this matter, item.
Victor, the matter will remain in the list. Interim order.
But we have complied, my lord, sir.
Which one, sir?
I'm respondent claimant.
Which contempt?
20 and 21. He's the respondent.
No, somebody said we have complied with the order. CPAN.
No, that is the other matter. 2021 is compensation matter. Employees compensation matter.
All right, let it remain in the list. Sir, Mr. Pathak, call 27, 28.
Item number 27.
My lord, I am for the appellant, my lord. My lord, 27, 28 has been complied with by the direction, my lord. What happened, my lord? Only 27 in item number 27, the appellant has refused to accept the employment, but 28, my lord, he has already joined our post. My lord, already one observation, my lord, regular salaries as indicated by the order.
We'll give
27 and 28 is submitted by the learned advocate for the applicant that the order and direction has been complied with. Recording the said submission, the contempt petition stands disposed of.
But only on observation, my lord, the regular salaries are indicated by the order that will be regularly paid. Well, that is a specific.
That is another contempt.
My lord,
may the affidavit of compliance be kept on with the record.
The affidavit in compliance is kept on record.
We are grateful, my lord.
Grateful, my lord. Grateful.
29.
29, my lord, I am.
My lord, 29, I am the respondent, my lord. I am led by Mrs. Chandrai Alam, my lord. Today, your lordship's direction was there to file an instruction, my lord. May I leave to file the instruction on behalf of the...
Give them a copy and file it. Let them go through.
My lord, I am the learned junior of Mrs. Chandrai Alam. I am.
You give a copy to the learned advocate appearing for
lordship.
the applicant.
Lordship.
The copy of the instruction received by the learned advocate appearing for the alleged contemnor shall be served on the learned advocate for the applicant and be filed in court. List next week.
I'm grateful, my lord.
Yes, sir. Thank you.
Item number 14, my lord, we are appearing for the respondents. May it be taken up next week, my lord. Mr. Kaulul Bush is leading me in this matter. He is not in court.
Item 14 next week.
Yes, my lord.
What date you want, madam?
Next week, my lord. Lordship.
But I don't know, 15. I am also paying notice.
All right, next week.
30.
Yes, sir. Thank you, Ruman. Yes, sir, Mr. Galib.
Milord, item 30, Milord, that lawyers issue. Milord.
Yes, she is here. Madam is here.
Well, the respondents who had come up with the applications, they are not showing up for the last 3 occasions.
But problem is
insofar.
No, she said, but it is 140 now. Beyond time. So let it remain in the list. Next time.
I'll leave it to you.
Lord. Thank you. Lord. Thank you.